Well, on Wednesday last week, we were all witnesses when we saw the First Lady of the Federal Republic of Nigeria being received into the chambers of, that's both chambers of the National Assembly, where the report for the Constitution Amendment was being laid. She was there to give her support to some of the clauses which will be up for consideration in the upcoming constitutional amendment. Well, today the clauses will be voted on in the National Assembly. It was presented last week. The clauses will be voted on, and we'll be waiting to see just how things will eventually go down. It's going to be a very busy day. Oftentimes, sometimes it does extend past their usual legislative hours, but it will be very interesting to watch what happens. So this morning, we'd like to discuss just what we can expect from this Constitution amendment, which is the start of a very long, winding process. It's not the first time we've been through it, so what's going to be different, or what should we expect to be different this time around? We have with us this morning Mr. Alwar Rafsanjani, who is the Executive Director of Civil Society Legislative Advocacy Center, CISLAC. You're welcome to Sunrise Daily this morning.
Thank you. Good morning.
Well, everybody is beginning to run their own quiet, or sometimes it can be quiet, sometimes it can be loud, however it is you see it. Last week it was the First Lady. Yesterday we saw the NLC, the Nigeria Labour Congress, going to go and push for some of the things it believes should be priority in the Constitution Amendment process. What are your thoughts so far about how we have amended our Constitution? And are you... Well, let me start from that. Don't let me ask you two questions in one. What are your thoughts so far?
Well, my thought is that given the fact that since 1999, National Assembly, or rather the legislature and the executive, as well as Nigerian people, have all been canvassing and yearning to address some of those gaps noted in our 1999 Constitution. For example, civil society organization under the umbrella of Citizens Forum for Constitutional Reform have gone around from ward to local government, state, zonal, and national level, and many other organizations of Nigeria that are working on the issues of constitutional amendment. They've all got views of Nigerians on what are the contentious issues, what are the critical issues that our constitution required amendment. A lot of work, a lot of energy have been done, and some of those areas were identified. But because of the self-centered interests of some powerful groups, they never allow any of those outcomes to succeed. That's one. Number two, National Assembly has spent incredible amount of money doing this constitutional amendment. Almost every time you have a new legislature, a lot of billions are budgeted for.
Indeed, this year alone, 1 billion naira was earmarked for it.
And this year, the amount, amount was also, said to say, spent, in terms of consultation and other work done by the National Assembly. But the issue that is worrying Nigerians, and that Nigerians have been yearning and demanding for it to be seen, amended in the 1999 Constitution, appears not to be given too much priority. For example, one of the major, contentious issues, issues of, indigent dichotomy, or rather settlers problems, which has claimed so many people's lives and created a lot of discrimination, against Nigerians. That's one. Number two, the issues of fiscal federalism. Many Nigerians have been canvassing and saying that, look, if you really want to have a good system within our own law, we need to deal with issues of fiscal federalism. The same thing also strengthening the federalism issue itself, as well as also issue that has to do with land Use Act. Yeah. And also, part of what Nigerians have been demanding to see improvement. Of course, we just thought some aspect of it is the electoral, and political party reforms, and several other issues that Nigerians have been yearning and demanding for the National Assembly to give priority, devolution of power, name it. But what really shocked many Nigerians is that issues that were never canvassed during the consultation of the National Assembly, both the previous one and the current one. We just saw two major issues that have been more of like smuggled or ambushed by, against Nigerians. That has to do with the issue of immunity clause for the lawmakers and legislature. And the implication of this is that you are widening up the scope for impunity in this country. Even the impunity, even the immunity for governors and the president and vice president as well as deputy governors, Nigerians are saying that please limit it, because the way and manner in which Nigerians are seeing the impunity done under the cover of immunity is getting out of hand. Now, if you include another set of people, State House Assembly, principal officers, National Assembly principal officers, judicial officers, the impunity is going to be more, and the accountability will suffer. Secondly, Nigerians have also seen...
We're already beginning to consider the clauses which
no,
will be,
yes,
which will be up for voting.
But it is part of what is been listed to be considered.
Indeed. So we're going to come to that shortly. I mean, we're still going... I just wanted to get your impression of constitution amendment process over the years. And I think that you don't seem very optimistic that this time around is going to be any different. But we'll come to some progress that we've made, and perhaps maybe something that we can build on looking at this new process. But let me quickly introduce our next guest, or our guest who's also here with us, Mr. Victor Giwa. He's a National Coordinator Advocate for People's Rights and Justice. You're welcome to Sunrise Today this morning.
Yeah, thank you for having me. Good morning.
Good morning. Were you taken by surprise when you eventually saw the laying of the Constitution on the floor of both chambers of the National Assembly? Did that come to you as a surprise?
No, of course. The National Assembly have been making, they've informed Nigerians that there will be an amendment and a lot of... I think they collected about 187 memoranda that were submitted for, to the National Assemblies, and about 1,909 recommendations from various persons. So we really were expecting that
I think you've been able to squeeze that into 67
clauses. Into 67 clauses, 68 clauses now.
For consideration.
Of course, consideration right now, yeah. So I think we expected, and of course, we just saw the president assented to the Electoral Act. So it is within the same spirit that I think the National Assembly, is talking about the clause-by-clause amendment of the Constitution.
But from our experience, because some people have been not very optimistic about the process. They believe that some of the fundamental shifts we ought to have been seeing in our Constitution by now is not yet done. That's why we keep seeing every 4-year cycle another look at Constitution amendments, and they think that it ought not to be. Are you optimistic this time that we can muscle what we need to actually make this sort of shit? And I think it also depends on who you talk to, because some people see absolutely nothing wrong with the Constitution that we have. In fact, they don't even see any point with amending the Constitution. But some people believe that there is a problem. There is a fundamental problem with our Constitution, and it explains some of the challenges that we currently face. So how optimistic are you that things can shift this time around, if you're one of those people?
Yeah, the truth is that things can shift because Nigeria is progressive. We must move within the Committee of Nations. We must be seen as people who are serious and must be able to capture the yearnings and the interests of the various groups. Nigeria is a country of over like 36 states with over more than 300 ethnic groups and interests. So there is no way that you must not look at this document that captures the generality of the interests of the people to see that it reflects the yearnings of these persons. And you need to look at the clauses, and you need to look at what Nigerians are asking for. But one of the things I did observe is the fact that when I look at those 68 clauses, I didn't see the issue of state police, which has been a very burning issue. But if you look generally at some of those clauses, you'll find out that there were some bold steps taken, to address certain fundamental issues. For example, if I would say, you will see a clause, a bill for an act to amend the Constitution to contain the fact that the judicial officers are now given timeline within which they can adjudicate on certain facts. You will see a situation again where a bill for an act to provide the fact that courts, the trial court and the appellate court, are given timeline within which they should dispense on civil and criminal matter. Those are good innovations. Those are the things we want to see. We saw a situation where, or we are seeing some clauses that also made provisions for women. Of course, like I was discussing with a friend of mine, I said the women have a lot of I don't know whether they've been able to do their work right from the homes. If not, we have about 3 clauses that made reference to women. We saw the issue of special seat for women in the National Assembly. We saw the provision of action, affirmative action for women. We saw a provision for special quota system for women. So, well, I told somebody that sometimes maybe the National Assembly have intention to change the human right to women's rights in the 4th chapter of the Constitution. But that is just by the way. Now, there are some good innovations that have been introduced. I also have issues with the fact that the traditional council have been increased or have been elevated in such a position where they now start providing advice for governors and for president. I don't think it is good. But we have seen some other provisions.
Why don't you think it is good?
Yeah, because traditional rulers should be left for the purpose of providing, talking to their communities, and they should not be elevated from being traditional leaders to political advisors, because by that clause, it said that a bill for an act to provide that both traditional and state, there should be National Council of Traditional Rulers and State Council of Traditional Rulers who shall provide advice to government, to the president and the governor of a state on security, custom, and public order and other related matters. No, our traditional rulers should not be reduced to political advisors for politicians.
But believe that the traditional rulers should be recognized by the Constitution. As it currently stands, they believe that there is no role for traditional rulers in our Constitution. And oftentimes when the security challenges come up, we always, run to the traditional rulers. In fact, in a conversation we had with the president at the beginning of this year, when we're talking about why he doesn't accept state police as an option, he talked about the role of traditional rulers. He believes that they hold the key to understanding our security situation. Yeah, so if that is the situation, why don't we put that role in the Constitution? No, the traditional ruler should be the conscience of people in the community. We are talking about devolution of powers. So their function should not be elevated to political positions. Of course, that is why we are saying... How do we provide for that in the Constitution? It doesn't have to... You see, the problem we have, and I saw a situation where even in one of the clauses is that it would be for an act to provide the procedure for removal of presiding officers in the National Assembly. You shouldn't have such provision in the Constitution. It should be in the National Assembly rules and guidelines. It is not everything you put in the Constitution. So there are various states acts that, of course, all traditional rulers are established by the local laws of the state. So you don't need to have that in the Constitution of the Federal Republic of Nigeria. However, we should be able to say that the traditional ruler should be the conscience of the community. We are looking at empowering the local government, like what we saw. One of the provisions is devolution of power to the local government. So you see, elevating traditional rulers to become political advisors to president and governors, as the case might be, is trying to overbloat the political system, which we are even saying that the political offices are too overbloated. I am not undermining the fact that traditional rulers play a key role, but those are not things that should be in the Constitution. That is the point. Okay, so now talking about a fundamental shift, and I'm still going to come to you, Mr. Rafsanjani, but talking about a fundamental shift, looking at all the Constitution amendments we have been having, I think that we've had, there are those who believe that the National Assembly is not capable of, doing the kind of Constitution that would actually move this country forward. There are those who continue to ask for, beg your pardon? Referendum. A sovereign national conference. I mean, there is that movement. It's been on, I think, since the time of General Sani Abacha. And we've seen attempts to try and bring up those kinds of conferences. And they have been, as late as 2014, we still saw something very recently. But there have been talks about our constitution amendment process and what really has come out of it that, we can say fundamentally has made a difference. Can you highlight any? Yes, of course. One of the recent
alteration is the fact that you saw the not too young to rule bill that was introduced into the constitution.
Not too young to run.
Not to run, sorry, not too young to run, that was introduced. That has to do with the amendment of certain provision to expand it so that younger person, that is one of the recent development. We also saw the fact that certain courts have been recognized in the constitution, unlike what it was before. So those are the new development in the constitution.
But when I talk about a shift, so perhaps when I talk about a shift that has really made a difference, something that we can all say, oh, but for the amendment of this constitution, we wouldn't have had it like this. I mean a positive shift, of course.
Well, you see, the constitution, well, one of the also amendment that also brought something was the issue of the doctrine of necessity. When, of course, when Yar'Adua died, and the question of was who and at what point the vice president should be sworn in. That alteration was brought in as a result of an amendment of the constitution. And if you look at this current amendment, like I said, as he was making reference to the issue of what the National Assembly was looking at is the expansion of immunity for the legislature and for the judicial officer. Now, that undermines the point that National Assembly are not competent to amend the Constitution because sometimes they amend those provisions to suit themselves. And that is the point you are making, where people are saying the best form of amendment should be that is done by some selected people who should be put in a certain places, done from various community, ethnic groups, religious groups of various interests to capture the various interests of these persons. That putting the amendment of a constitution that is very fundamental should not be, the amendment of the constitution that is very fundamental should not be kept in the hands of 106 senators and 360 members of the House of Representatives. That the interests go beyond that. So we need to see.
Let me be more specific. There have been a few attempts. Right now, I think back in the Constitution Amendment is the local government autonomy. There is state police, which you say you
the state legislature and the state autonomy for the State House of Assembly
yes,
and the
indeed.
State Judicial
That is also
office.
There as well. State police, you say you didn't see it here.
It's not there,
These are agitations that have been, there's also been talking about restructuring our federal allocation system. There are those who talk about resource control.
Yeah, derivative formula.
Exactly.
Yes.
These are agitations that have been on for because they believe that fundamentally these things have the potential to unleash the potential that is inherent in our country. So for you, I do not know what your take is on any of this. Let me come to you, Mr. Rafsanjani. What your take is on any of these agitations that have been on for a while. This time around, I mean, we've seen attempts by state governments, for instance, to do some form of, they say it's not state police, but we've seen Amoteku. We've seen Ebubeagu. Perhaps we don't know what else we might see, but there have been some efforts by state governments, and you think that this is something important enough to make its way into the Constitution Amendment. So for you, how hopeful are you that this time around we might be able to see this sort of differences, things that people can point to and say, it wasn't like this but for the amendment of the Constitution?
Thank you very much. Since 1999, when the democracy is returned in Nigeria after a struggle by largely civil society activists, I have been also involved since 1999 on constitutional amendments, agitation to make the process to be transparent, to be inclusive, to actually, allow for Nigerians to ventilate those angers and concern and the yearning they have in order to make Nigeria workable. Some of the issues listed are still part of it, but substantial number of those issues have not been captured. And that's why we say, look, let's look at the contentious issues that since 1999, the political class in Nigeria have failed woefully to address them. And those are the basis on having peaceful coexistence in this country and making Nigeria to work, in a very fair manner. The issues of resource control is one of the key agitation that Nigerians are legitimately making. Issues of federalism, true federalism, because the confusion sometimes you have, Nigeria is supposed to be practicing federalism, but the confusion that we see is that it is not simply properly, defined and followed. People are saying that, look, let us have a clear, direction on our federalism system. Nigerians are talking about the pillar of the government to not to decentralize security in this country, making it difficult for even the state governors to take certain responsibility without clearance from Abuja. Nigerians are saying that, look, let us look at our security architecture and do something about that. Nigerians are saying that, look, this issue of settlers, indigent, dichotomy that has continued to be a major problems in the country, let us address it. Nigerians have also been talking about the fact that, this whole issue of Land Use Act, need to be addressed. And numerous issues, but one of the key things that I also know that Nigerians have been agitating is that the separation of office of the Attorney General and Minister of Justice. Secondly, the Auditor General of the Federation has been reduced to simply an NGO. Every year, they will do their, report, they will do their audit, and the audit has no any meaning. Nobody does anything. Nigerians are saying that if we are seriously, especially now that we are talking about anti-corruption, if we are serious, we should give that office a proper legal recognition and backing. Again, Nigerians are talking about the fact that the legislature at the state level has been undermined by the executive. There are quite a number of them that have been captured, but there are a lot that were not even part of what Nigerians have actually been canvassing since 1999. And even memorandum that Nigerians have submitted did not include some of those self-centered interests that we have seen be listed. For example, part of what they want to consider today is to have, permanent pension and gratuity for the National Assembly and State House Assembly principal officers. I think this is not fair. You've collected, reasonable salary and allowances, and now you want to permanently accept to be collecting, money even after you left National Assembly.
And it's in the Constitution?
This is part of what they are considering today. So I think the economic force is not going to, sustain that. Secondly, it is what is triggering political violence, because once you can get permanent, money, even after you serve in the National Assembly or State House of Assembly, the interest to be in the to capture power is going to increase. And in other words, we are going to create more tension for our election and electoral process, simply because people know they want to secure their life perpetually. I don't think it is fair. Nigerians are not even getting decent salaries. Now you want to come and collect more money. The economy cannot sustain it, and there's no fairness, So I'm saying that National Assembly should go beyond self-seeking interest. They should forget about this immunity clause they are trying to give to themselves. I think if you do that, you are going to create lack of accountability by many political actors in this country. And what are you even afraid of? If you know that you are not planning to perpetrate crimes and commit more atrocities, why are you afraid? We are even talking about limiting the powers, the immunity that covered the president and vice president and governors and deputy governors. Now you want to include yourself. I think there are more serious issues that Nigerians are begging the National Assembly to look into. Look at the National Conference, 2014 conference, which brought together different diverse interest groups, politicians, academicians, traditional rulers, civil society, even legislators, ex-legislators, many number of interest groups were there. And they made a lot of issues were discussed, debated, and many of those issues were also arrived at consensus. Unfortunately, the government that even brought that conference, when the report came and they noticed that it was not in their interest, they abandoned it, because that report came with three things. First, issues that has to do with the constitutional amendment, issues that has to do with legal framework like bills, issue that has to do with policy that even the president himself can initiate that. I tell you, all of those things were help to address the problems that we are facing, but the government did not do anything. Of course, this government has spent 7 years now. They did not even look at that report.
And they even came up with their own restructuring.
It is supposed to be a continuous thing. Why do we have to spend billions of taxpayers' money and abandon all this? I think I want to plead with the National Assembly that Nigerians are looking, onto them to do things historically. If the previous constitutional amendment has been failing because of selfish interests, this one, they should not also allow it to collapse and therefore vote on those issues that can make Nigeria great, that can make Nigerians feel like they're Nigerians and that they will make Nigeria productive. This issue of, creating additional states, they are all, waste of time. That's not what Nigerians are talking about. The issue are very
Some people argue differently. Some people will say that there are those who feel marginalized in their state strongly enough to be clamoring for
even local government. Some people will say they are marginalized. Look, if we don't have fairness and justice in this country, if you scatter Nigeria into 1 million, some people will still protest because of the absence of justice, the absence of fairness, the absence of inclusion. If you don't have those principles, I am telling you, no amount of state creation can address these problems. We have to be fair, just, and inclusive in what we are doing in this country. Otherwise, this tension will continue to grow.
Let's take this conversation now to my colleague in Lagos, Ayo.
Thank you very much, Mark. Mr. Fanjani, one of the issues you mentioned about this process is that the hope for good governance, or should I say better governance. And you also hinted at the local government, issues around local government administration and all of that, which is one of the thematic areas or issues bordering on this process of the constitutional review. The Constitution is clear about how local government administration should run, but it would seem like up until now, we are operating those sections of the Constitution in breach. Now there are considerations for local government, around local government administration and autonomy. How much of a game changer do you see that being?
Well, if we really, cares about local government autonomy and grassroots democracy as well as local government development, I think you have no option then to allow local government to function effectively and efficiently, because it is the first point of even politician or any development coming, because majority of Nigerians, they live in local areas. And if at the local government areas, you are not able to have a system that will also be run democratically, that will also be run through, with accountability and also encouragement of, development at that level, you are basically undermining even the growth of the
Mr. Rafsanjani, that's part of what the Constitution already says. Just one second. Some of these things that you're talking about are some of the provisions already in the Constitution as is. How much of a game changer do you see these proposed amendments to issues around local government administration and autonomy? How much of a game changer is it likely to be if the ones that we are operating now were operating in breach?
You see, as we are progressing in this democratization, we must continue to insist and advocate that right thing being done in this country. Because it's been practicing wrong does not mean that we should keep quiet and be silent for it to continue. We must continue to advocate, for all those gaps that, we have noted in our systems. It's very clear the level of impunity and the level of corruption you see in various tiers of government, which of course include even the local government, has tamper or hamper development. And we are saying that if we really want to improve on some of these issues, the local government autonomy should include financial autonomy. You cannot be there and you have no really autonomy. State governors appoint local government chairmen. They collect, or indirectly or directly, they actually, control their revenue, which comes from federal government. And we are saying the changes we want to see in this time around now is that completely governors have no business imposing on the people at the grassroots level who should run or who should be their local government chairman or their councillor. They should be allowed to independently, run the system so that they will be able to learn, because the best place to learn democracy is at grassroots level. When you are a councillor, when you perform very well, you can come and become State House of Assembly. When you perform very well at the State House of Assembly, you can have the potential to come to National Assembly as a House of Rep or as a senator. But if you are lacking all these experiences at grassroots level, it becomes difficult. Just, because you have money, you just come and become a senator overnight, and you don't even understand the legislative process. It takes some time for so many people to even understand the rudiment of legislative processes and to be productive, in the work of the National Assembly. So we are saying that let us allow the local government to have its own political, autonomy, to have its own economic autonomy, to have its own development strive. Because if you don't allow that to happen, then it becomes difficult for grassroots development, either politically, either economically, either even socially, So it is important that National Assembly vote wisely with the mindset that what they are voting on local government autonomy includes them to also have financial autonomy with a clear accountability framework. There must be proper accountability framework on all this. The same thing also, we are talking about judicial, autonomy. There's no way a governor will be the only one to be giving you the pocket money, to give you money to run, the court, and then, issues come that he has interest or she has interest, and then they will not do anything. Because of the absence of that autonomy, they are likely, to follow the governor, since now many people have lost their, obedience to the Constitution of Nigeria. They are interested in regime protection and regime following. If you have this governor today, your loyalty is to him, not to the law, not to the people. If you have this president, some people believe that it is only loyalty to the president, not even to the Constitution and not to any democracy. We have to change that narrative. And that's the only way we can consolidate democracy, because democracy is an opportunity for people to participate, in terms of, development, in terms of economic development, in terms of even political, inclusion. And you could see that if you do that, you will create a level playing ground for many people to actually contribute meaningfully for Nigeria, and for many Nigerians to really be proud that they are Nigerians. Now, unfortunately, because of the poor education, many Nigerians, they are not even, interested in Nigeria. And when they go out there, they'll start crying that they are Nigerians because they have been brutally, ruthlessly malhandled there.
Mr.
That's when they remember that they are Nigerians.
Just 1 second.
I think it is important.
My sincere apologies. Let me ask Mr. Victor Giwa the same question about local government administration, especially according to what the Constitution already says. Is there any way, Mr. Giwa, that you see this Constitution compelling governors in stronger language than it already does to ensure that local government autonomy is as it ought to be?
Yes, thank you very much for that question. The truth is that, first of all, we must understand the concept of constitutional amendment. Constitutions are amended to make it better, to make it reflect the interests of the people, to cover up some lacunas, to cover up some mischief, to cover up some mistakes. Now, talking about the local government and the state government, the truth is that Section 162 made provision for a state joint local government account. Now, that is what the governors have exploited against the local government, such that local government local government chairman just go to their local council every end of the month to collect what the governor gives to them. In short, we have cases where any money that gets into that state local government account, the governor takes custody of them and dictates to the governors, to the local government, what they get, not what has been allocated to them by constitutional provision. So local government just come hands down to the governor to determine, to collect what the governor have determined for them. So what this constitutional amendment has done, or one of the clauses, is to have a state and a local government independent account. Now, that provision of Section 162 was that when the money comes from the federation account, it goes straight to the state joint local government account. And in that account, the governor calls the shots. The governor determines what the local government gets. The local government chairman cannot complain because based on our political system, the governor are emperors. They determine who becomes chairman. Some of them, you can even see some governors are removing local government chairman.
How does this amendment, just a second, how does this amendment, just one second, Mr. Giwa, how does this change the paradigm, this provision?
Good question.
Go ahead.
Now, how the change this amendment has brought is that now the allocation of the local government from the federation account goes straight to the state governor for that of the governor of the state, and that of the local government goes straight to the local government accounts. So the local government chairman becomes the accounting officer for that local government.
Okay.
They will have their budget. They will have their budget, their expenditure. They will have their accountant and all of that. So that is the fundamental difference. Okay. Unlike what it is in the
just on that, Mr. Giwa, just a second. On that, you know that now we have, according to the Constitution, 774 local government areas. But then we also know that in some states in the Federation, we have what they call local council development areas. Those are not captured in the Constitution. Now, what happens then? Do you see a situation where the local government where these LCDAs are cut out from will sit together? How is that to be addressed, in your opinion?
Now, first of all, the council areas, what they call council development areas, as in Lagos, Ekiti, and Ibadan, they are not local governments. And that case is very settled by the Supreme Court in the case of Attorney General of Lagos State versus Attorney General of the Federation, 2002, determined by the Supreme Court. Now, the court position is that those council areas are premature local governments. The court says that it is a process of creating a local government that is equate. So they are no local governments. They are premature local government. They are not known to law, and they cannot, as it were, be amongst those local government that should receive allocation from the federation account because they are not known to law. So what this does for those council areas, what the local government will do, what the state government will do, they will apply some political solutions that will determine on what is the political party in that particular state. Because I cannot imagine, for example, if I am in Lagos State and I'm the chairman of a local government and I'm a particular party A, and my governor is party B, and monies come into my local government, I'm not going to share it for the purpose of giving it to other development.
Mr. Giwa, don't you see confusion coming from that?
Now, what the new constitution will do, it will not try as much as possible to make the governor know that they need to go and complete the process of legalizing those council areas, because as of now, the constitution only recognizes 774 local government and allocations. Like you rightly said, we move straight to those local government that are recognized by the Constitution, and those area council, maybe they will fold up, maybe they will be collapsed, maybe they will be begging from the authentic local government for their funds. But what this amendment will do is to make sure that local government become independent. You cannot argue them to collect money. You cannot muzzle them to collect money. They will be the accounting officials for the local government.
What's your outlook for today?
Well, you see, of course, I will expect to see a lot of resistance. I will expect to see resistance in terms of from the people. Of course, we've started seeing some diverging and opposing views in terms of the provisions of the Constitution. But in the National Assembly, I see it is going to be
resistance or their
advocacy. That is part of yes. We are going to have a serious advocacy against certain elements of the clauses for amendment. But like we said, there have been some good provisions. Will
that have any influence? I know that Mr. Rafsanjani already has an agenda.
No, but you see, the truth is that, like I said, this is the beginning process. Yes. Of course, these things will be subject to the state houses of assembly. But I need to say this, that we still have one of the provisions for amendment is that there's a creation of the office of the Minister of Justice as separated from the office of the Attorney General of the Federation. But one other part that to me looks so ridiculous was I saw a case where they said there will be an office of the Auditor General of the Federation and Auditor General of Federal Government. And I don't understand what that means. So why will you have an Auditor of the Federation and now of the General of the Federation and now have an Auditor General for the federal government? I know the point you were trying to make is that the Auditor General of the Federation should not be determining what goes into the various states. But I think that is duplication of office, which is one of the things that we're talking about. We understand the provision of the Attorney General, because of course, Attorney General is one particular office that is clear-cut, one ministerial office that is clearly cut in the Constitution, and we try to make sure that those offices are not too politicized, and that's the intention of making it different from the office of the Minister of Justice.
Mr. Rafsanjani, what's your agenda for today? In 30 seconds, if you
My
can.
My agenda for today is to continue to advocate to National Assembly members not to vote on those self-centered, seeking provisions like, immunity cover-up, so that more fraud, more corruption, more lack of accountability will be happening to many public officers. They should not vote on that one. Second, they should not also make a mistake of voting this permanent pension and gratuity, because Nigerians are dying, are suffering. Even the minimum wage is not getting to their stomach. And now, after collecting huge salaries and allowances and privileges of government, you want to now continue to milk the economy of the nation. That would be very, very unfair. So they should not vote on those things. So
well, 30 seconds over. Mr. Rafsanjani, I have to thank both of you for coming on Sunrise Daily this morning. Omar Rafsanjani is Executive Director, Civil Society Legislative Advocacy Center, and Mr. Victor Giwa is a National Coordinator, Advocates for People's Rights and Justice. Gentlemen, thank you so much for coming on Sunrise Daily this morning.